Sir, yeah.
But here we are challenging Annexure P9, that is an order passed by the District Court Bhopal in exercise of power under Section 9 of the Public Premises Act, my lord. Hereby, my lord, the order passed by the state officer was my lord. So that order under challenge before your lordship.
Annexure
Annexure P9 में kindly see.
P15.
Volume. It is
P.
It is P15, my lord.
Order dated 18/9/2024.
My lord, that is.
Yes, P15.
My lord. So this order is under challenge, my lord. This order I am challenging, my lord, on all the counts, my lord. The order is number 1 without jurisdiction, my lord. I am saying, my lord, because the proceedings under Public Premises Act is not maintainable. Number 1. Number 2, my lord, the demand which has been raised, my lord, for recovery, my lord, is exorbitant, my lord, towards the rent, my lord, and other dues, my lord. And for that, the proceeding instituted, my lord, those are there's procedural impropriety.
What is without jurisdiction as PP Act proceeding is not maintainable?
My lord,
Which is the other point?
My lord, that is, my lord, the entire matter.
No, just you were listing out the points.
My lord.
One is without jurisdiction.
My lord.
What is the other point?
The other point, my lord, the demand is wholesale arbitrary. The policy which they are relying, my lord, it is not at all applicable on the open plot, my lord, for recovery of this license fees, my lord. And therefore, my lord, only the dispute with respect to demand of this license fees, my lord.
What was the relationship between the parties?
But the license has been executed, my lord, in 2009, my lord,
What
with respect to open land, my lord.
What page is the license?
My lord, it is Annexure P1, my lord.
Yes.
My lord, it is at page 24, my lord. License patra, my lord, I am reading, my lord. It is प्रमाणित किया जाता है कि श्री Jyotinder Singh.
You come in by this document.
My lord, this document, my lord. Possession has been given by virtue of this document. And it is, my lord, from.
1 second. It says you were in possession since 2003.
My lord, we are in possession.
So how did you come in possession?
My lord, by virtue of this license, my lord.
This is 2005.
My lord, earlier, my lord, what had happened, my lord? This is my ancestral. Earlier, my father, earlier grandfather, then my father, then I was given, my lord.
They were licensees?
They are the licenses, my lord. They are the licenses.
Your grandfather was given this place on license?
My lord,
where is that document?
My lord, we have pleading is there, my lord. It is undisputed pleading. I can show, my lord, from para 13 and 14 of my reply to this application. The reply to section 5 and 7 component application.
All right. So the terms and conditions of a license are mentioned in this?
This, my lord.
What are the terms and conditions?
But terms and as per the stipulation, my lord, BHL द्वारा 2011 के लिए निष्पादित किया गया है निबंध शर्तों पर BHL उद्योग नगरी सेक्टर ओपन प्लॉट व्यवसाय के लिए दिया गया है. So it is for open plot.
कहाँ पढ़ रहे हैं?
Page 24 annexure P1.
Page. First page.
My lord. ओपन प्लॉट व्यवसाय शामिल स्टोन करने हेतु.
By hand it is written open plot.
Handwritten, my lord, it is hand. करने के लिए BHL प्रबंधक द्वारा पूर्व में अनुमोदित मानचित्र व्यवसाय करने हेतु अनुमोदित प्रदान की. तो my lord, it is an open plot, my lord.
And what are the conditions?
My lord, conditions has been stipulated from the next page, my lord. यह करार करके एक पक्षकार के रूप भावत एविक्शन लिमिटेड भोपाल भारत सरकार का कंपनी नियम 1956 के अधीन कंपनी इसका रजिस्टर प्रधान कार्यालय नई दिल्ली में है. इसके संदर्भ में अन्य आवश्यक न होने पर उसके उत्तराधिकारी और पक्षकार के रूप में ज्योतिंदर सिंह सलूजा पक्षकार लाइसेंस दिया गया है. बीच में 23 जनवरी 2009 के दिन किया गया. लाइसेंस दाता निवेदन किया गया कि लाइसेंस दाता लाइसेंस भारत हेवी इलेक्ट्रिकल लिमिटेड.
Talk of any piece of land or premises?
But it is only a piece of land, my lord.
The terms are silent about it?
My lord, these terms are silent about it, my lord. But it is for license, my lord. It is for license. On the piece of land for license purpose.
So because first talks of open piece of land on a license basis.
License basis.
There is no other specific condition.
No, my lord, there is no specific other conditions, my lord. With respect to this, my lord, but other condition, what would be the effect when somebody would die or something like that, my lord? So these are the general conditions which are mentioned in the licenses, my lord. So that is there. Now, my lord,
Why is the expression shop used in it repeatedly?
Well, there is an act, Shop and Establishment Act, my lord. That is there.
So what is licensed to you? A shop?
It is for open plot, my lord. License only for open plot, not for anything, my lord. This is the admitted position. I am demonstrate from the further documents, my lord, if my lord permits me.
1 second. Sorry, sir.
They've only allotted land, my lord. Nothing more than that. So, my lord, thereafter, my lord, till 2011, my lord, we are paying regular this license fees and other dues, my lord, to the respondent. And after expiry of that license period, my lord, right, annexure P2, my lord, we moved an application for the renewal of license, my lord. Page 35, my lord. And I specifically mentioned that आज दिनांक तक कोई बकाया नहीं है, and I am ready to fulfill all the conditions.
So what transpired after this license?
Then, my lord, what had happened? Other applications has been there.
This was never extended or renewed?
Well, it was never extended and renewed, my lord.
2011.
My lord, I am regularly paying license fees and other dues to the, my lord. Thereafter, my lord, what had happened in 2000, as per the respondent's case, my lord, this arrangement is continued till 2019, as per me, till 2020. Those documents I will demonstrate, my lord. My lord, thereafter, my lord, these things are going on. And now the issue would come with respect to annexure P4, that is a shop policy, my lord. The current dispute is based on, the respondent case is based on annexure P4. They are saying the shop policy applicable in my case. We are disputing that this shop policy is not at all applicable in our case because it is not for open plot, my lord. So whatever the demand they are raising, my lord, on the basis of this policy, if this policy, since this policy is not attracted, then we are not liable to pay any amount in pursuant to this policy.
Let's look at the policy.
But let's kindly see clause 2. I am reading page 44, my lord. And clause 2.4 is the relevant, my lord. Straight way I am coming to the point.
Yes.
When the policy is not applicable to any allotment of vacant land and or
Where are
construct.
you reading?
2.4, page 44.
It applies to fresh allotment of shops,
Shops.
then bringing the
2.4.
1 second, we'll come to that. Fresh allotment of shop, bringing existence licenses to model license agreement, management of license and according to license agreement. Policy is not applicable to allotment of any vacant land and or constructed premises. So how do you come in this?
But I am not, because my lord, it is a vacant land, it's
It's
open.
not a vacant land.
It is an open plot.
It was a vacant land in 2003 when your grandfather was given it. At the time.
No, my lord, my license is also for open land, my lord.
Vacant land is different from open land.
Open plot.
Yes, allotment of a plot is different from a vacant land. Vacant means on the date of the policy, a land is vacant.
My lord.
Why will it not be covered under 2.2?
But at 2.2, my lord, it is, my lord, bringing the existing license granted, modern license.
2.1 is fresh allotment of shops. You are not covered under allotment of a shop.
Fresh allotment, I am not.
You're not covered. 2.2 says existing licenses. You are an existing license as per your
Being existing license
in
agreement.
terms of the model license agreement. Why will you not be covered by 2.2?
But because, my lord, it is other ingredient may kindly be seen, my lord, of this. Other conditions, that is that management of the license in accordance with the license agreement and with the policy. The policy is not available to any allotment of vacant land or constructed premises of central or state government, department, semi-quasi government and institution of BCL, trade union, employee
So
association.
this is not applicable to vacant land.
And my lord, the definition of shop is also there, my lord. That I come, my lord. Gradually I am coming to that, my lord. So, my lord, the
Now,
policy is not.
The 3.1 shop.
Shop means,
Definition of
means any space oblique place from where commercial trading activities are carrying, including allotment of BHU constructed shop.
Read 3.
3, where only land was allotted by a company, permanent construction has been undertaken, and so I have no permanent construction is there, my lord. In my
What have you?
my lord, only the steel shed is there, my lord. Temporary structure is there. There is no RRC, no.
There is a construction made.
Construction has been undertaken. So no construction.
Undertaken a construction.
No construction.
So all shops are also temporary.
No, my lord. It is meaning of this. It is this is RRC construction, my lord. It is not fixed construction.
So if somebody were to build a shop with a porta cabin, he'll be excluded.
My lord, my respectful submission, there is a condition, my lord. The shop means, my lord, there is a pakka construction, RCC construction. Then only we treat it as a shop.
Shop is a shop. Construction being made permanent. Construction of porta cabin is not RCC, but still a shop.
Where only land is allotted, my lord. The clause 3 is very clear, my lord. Kindly
So land was allotted to you.
My lord.
And then a structure is made on it.
And construction has been undertaken. I have not made any construction. That is the issue. If I have made construction, then what my lords are saying, that is absolutely correct. Then my lord, kindly see clause 4.3.
Yes.
My lord, it is for all types of shops mentioned in the rule 3.1, minimum monthly. So my lord, this reserve license fee shall be fixed ETSC unit level, which no case should be less. Reserve license fee as per formula.
This is fresh allotment.
It is for fresh allotment.
So are they giving it to you afresh today?
No, so far Jyotinder Singh, it is a fresh allotment. It is in my father's name, grandfather's name.
No. After the policy, you see, there are two things, Mr. Sharma. One is your license stands terminated.
My lord.
You have requested for renewal.
My lord.
They have neither rejected nor considered.
My lord.
At least we don't know. They could have rejected, but you've not been communicated.
My lord.
After the policy, 4.2 says fresh allotment shall be made by following tendering process as mentioned below.
My lord.
And 4.3 fixes the rate.
My lord.
So if an allotment is being made to you today,
My
it will be at this
rate. By this, at the time of existing operation of this policy. But for the old, my lord, it is not.
If no allotment, if your allotment is not being extended,
my lord,
license is not being renewed,
my lord,
then we'll have to see what is the charges they can take from you. Can they take it at this rate, or can they have to go by the earlier condition?
My lord. My respectful submission is this, my lord. Number one, my argument, we are not fall under this policy, my lord. So far rates are concerned,
But Mr. Sharma, the problem is this. Whether a policy or not,
we have to pay, man. We have to pay. We have to pay.
No pay. You are a licensee.
I am licensed,
You have no right to continue without, except with their consent and permission.
my lord.
So first and foremost, what about possession?
But the possession has been given in 2003, my lord.
You don't become owner by adverse possession.
No, I am not owner,
So they are today demanding possession
my lord.
and damages.
My lord.
How do you hold back possession? First and foremost, we'll come to damages later. How do you hold back possession? You are a licensee. As per them, license stands terminated, PP Act proceedings initiated. First is vacation of premises, second is license fee.
But the limited issue is this, my lord, my respectful submission. So far, there's a dispute is with respect to demand of license fee only on the basis of this policy.
1 second. Mr. Lalwani, are you agreeable to them continuing on payment of license fee as demanded by you, or you want possession?
We will give them if they pay all the dues from 2014.
So possession,
New policy.
Mr. Lalwani, one issue is this. If you are willing to rent it out to them, license it to them, we'll determine what will be the license fee that you.
License will be as per the new policy upheld by the court, argued by Mr. Sharma.
Policy may have been upheld, whether it applies to existing.
Yes, they applies to.
That's a finding on that.
Yes, there's a, now there's a finding, this is a petition 227, not 226.
By a division bench or a single judge?
By division bench, that was a petition filed by them, policy of virus was challenged.
By them meaning this petitioner.
Not, he is a member of the
This is maybe.
association,
That's an
which
association.
had filed it. And the council was the same, we have annexed that, it has been held.
This is a different person.
ठीक है, हम आएंगे ना.
Mr. Sharma, there is one difficulty. As a licensee, you have no right to continue, except with their consent. Mr. Lalwani says, as per their calculation, from 2014, if you are willing to pay, they can consider extending your license. Else, license is over. Then the question is this: if you accept their 2014 demand, then they'll, whatever is the license term, they'll give you the license and you will continue. If you don't accept it, then as per Mr. Lalwani's submission, possession handbag will determine what are the damages you are liable to pay. You can't say that because you see license, there are several judgments. As a licensee, you can't insist on holding on possession. Even if wrongful termination, your remedy is damages. But in this case, license ended in 2009 or 2011, no further extension, maybe pending. They say as per a 2000 policy. So you have to take a call. If you want, it's an offer. If we're not saying you take their call, you have to make a decision. If you accept their whatever illegal demand, then they'll continue your possession. But Mr. Sharma, you can't continue in possession and dispute their demand. You surrender possession, we'll consider whether you are liable to pay this for the past or not.
They have surrendered.
No, not yet.
Possession is surrendered.
No, not yet surrendered.
You locked it.
No, only sealed, my lord.
How it has been executed, I'll show that.
No.
I'll show that.
Not yet executed.
How it has been executed, I'll show that.
Who's in possession?
I am in possession.
I have sealed it. It's
We are in possession.
Mr. Lalwani, we had appointed a commissioner.
My lords also passed an order asking us to de-link it and de-seal it.
Mr. Lalwani, premises lies sealed.
I'll show how possession is taken, what the Supreme Court says on possession, how possessions are taken.
Mr. Lalwani,
And the PPH says,
Mr. Lalwani, that is something we can determine. Right now, Mr. Sharma,
PPH says how possession is to be taken.
Mr. Lalwani, Mr. Sharma is at a fork. He has to take a call. whether you want to continue in, because what you just said, you are willing to extend the license if from 2014, they pay the entire demand as your demand. It's an offer. Willing to accept it, you can consider it. If you're not willing to accept it, surrender possession and we'll consider about the damages that they are charging from.
My lord, my respectful submission, my lord, to that effect. My lord, kindly see that there is any reconciliation with respect to what is their demand and what is their documents are
Mr.
saying.
Sharma, please understand one thing. It's a license.
They are, my lord, state under Article 12 and they have to act in just and fair manner.
Mr. Sharma, there are several judgments. I am author of some of them, which say as a licensee, even against the state, your remedy, if at all for a wrongful termination, is damages. You can't hang on to possession. If you are willing to surrender possession, we will deal with the aspect of damages. Else, you'll have to toe their line. Up to you.
But kindly appreciate 2-3 things.
You can't say, I will continue with possession, but decide on damages. That can't be. You want, we'll give you several judgments on that aspect, that as a licensee, if you were a lessee, protected tenant or something under the Rent Control Act, the situation would have been different. You're a simpliciter licensee.
My lord, then kindly keep it in the next week. I will review the things, my lord, then come forward.
No, you asked him.
My lord, I will consult with my client, my lord. Some time I am seeking for that.
Lunch के बाद अपने client
Not today.
Client is sitting.
Not today.
How much is the demand?
about 8 crores.
No, not it, sir.
It was 2 crores something from.
My lord, order is, my lord, order is.
Mr. Lalwani.
My lord, they will demonstrate it, my lord, how they were right.
I mean, my lord's protection to answer my lord's question.
Mr. Lalwani, from the date you have sealed the premises and so-called taken possession, you can't charge them anything.
ठीक है ना? वहां तक तो लेंगे ना हम? वहां तक ही बता रहा हूँ.
वहाँ
Up to
तक
24 बता रहा हूँ.
please communicate.
It is up to, they know it. They know it.
My lord, sir,
It is in
my
the
lord,
order itself.
only few documents I want to demonstrate, my lord.
From 18 is in the order. 18 to 22, it is 2 crores something. I'll just give it to my lords. Let my friend also have it. This is the I'll give it to my friend. Nehru, wait. Can I pass on the calculation? In the order, it was from 18 to 22. Actual calculation when the policy was became applicable as per the High Court judgment also. It's from 14 to 24 now. This is the calculation.
That's what Mr. Lalwani.
But there's no-
Situation is Mr. Lalwani's situation. Mr. Sharma point is very different. You may have an argument on clause 22 of your original license, but that we will consider once you surrender possession. You can't say determine my rent as per the license agreement and continue my license. We will not be in a position to continue your license. To continue your license, you have to ask them, request them.
My lord, my respectful submission, my lord. We are always willing to pay them, my lord. There is no difficulty for that. But so far, it should be a reasonable amount. My lord, even kindly appreciate 1 or 2 minutes.
We can't determine reasonable amount.
My lord, only one order, my lord's order is already there for that. Kindly see para 14 and 15, my lord's order, which say if you have given land, you can charge for land, not for constructed shop.
Mr. Sharma, that is not the point. You are a licensee. Even if your license was in existence today, they could have said, we terminate it, go. Your remedy would have been damages, not hold on to possession. That's the difficulty. If you want to retain possession, unfortunately, you have to toe their line. Else, surrender possession and we'll determine whether clause 22 of your original license will apply or 2014 policy will apply for the past period. You can't hold on to possession as a licensee and say, I will contest on damages and continue my license. Then it will continue for how many years? In perpetuity. License deed is always terminable.
That legal proposition I am not disputing,
have-
but my lord, the amount should be reasonable, my lord. They will guide it, my
For
lord.
a license, Mr. Sharma, it's their property. They say we'll give it at we'll sell mud at the rate of gold. It's their property. Don't buy it. Don't take it. You can't say I will buy your gold, but at my prices. That can't be.
You can
Take a call. You want to continue in this place? You'll have to pay them. If you don't want to continue, surrender possession. We'll handle the damages aspect. We'll deal with it. then you submit on the aspect of damages.
But we want to continue the possession as well as
Then
we want
you'll
to
have to-
deal with this aspect of damages.
you'll have to-
But if, my lord, there is no demand under section 7(3), my lord, that is my case.
Mr. Sharma, we take it. Let's quash the demand. That demand is quashed as being illegal.
About possession license.
Possession, you'll have to surrender.
But my lord, they are the state article 14 would apply, my lord.
State not being forced to give a license. They're saying we're offering a license to everybody at this rate. And if you say they're state, then your very first argument, PP Act, no jurisdiction, false. They're state. They have the right to go under PP Act.
My lord, but my respectful submission is this.
Either PP Act is applicable, not applicable. If applicable, then your entire argument of Article 12 goes down.
Well, PP Act, my lord, so far notification of the land is not there, which has been under mentioned, my lord. That is there. But so far license part is there, my lord, that is separate issue. PP Act jurisdiction is separate issue.
Sharma, let's assume PP Act not applicable.
No, even then, my lord, even then, my lord.
License,
The same.
you can't continue.
So, my lord, kindly keep it in the next week, my lord. I'll take instruction, my lord.
इस बात के लिए क्या बोल सकता हूँ? Next week के लिए.
The arguments heard in part. Learned counsel for the senior counsel for the petitioner prays for some time to explore the possibility of a settlement. At request, re-notify on give or take. What's it? 6th March.
My lords.
Yes, ma'am. Yes, ma'am.